start because I'm conscious of time, and people will be able to join as we're going. So, firstly, hello, and thank you very much for joining us on our webinar today, which is part of our Employment Club series. And you'll be able to see on the screen there that we've called this an employment review of the year. So just in terms of explaining what we're going to do, the session will last for an hour. And speaking today are me, I'm Tim Woodward, a partner in the team, and my colleague Kate Watson, who's an associate in our employment group.
Hi, everyone.
Morning. Hi, Kate. And what we're going to be doing is we're going to be looking at, I suppose in our view, the key cases over the course of the year. And we're going to have time to look at 10 of those, and all the case names will be in the slides. We're also going to have a look briefly at some horizon scanning, so what's in the pipeline for employment law over the coming months. And as you'll see on your screen there, we're also going to use a couple of polls as we go along, which essentially are questions that will pop up on your screen there, and you can register your response. So as you ask the question, it should automatically pop up on your screen, so you can put in your response there. It's all anonymous, so you can't get it wrong. And then we'll get the results as we go and build those into our discussion. You'll also see on the screen there that we've got a question and answer tab. So as we're going along, if questions occur to you that you want to ask, please put them through the Q&A tab, and then they'll be saved, and we'll come back at the end of the session to have a look at those, and hopefully you'll have 10 minutes or so at the end to deal with questions. And as you'll see on the slide there, the session will be recorded, and we'll share that recording with everyone who's signed up as an attendee. So if you're extremely bored, you'll be able to make your own highlights reel of the talk today. So if I click through to the next slide, as I said, we've covered the content already, really. So say it's important cases over the year in our view. So obviously there's a subjective element to that. As I said, we'll look at some horizon scanning, and we'll do some Q&A. So without wasting any further time, if we head to our first slide there, we're going to be looking at 3 cases in the, I suppose, the unfair dismissal space that we think are very important. I'll be looking at K versus L, and then Kate will look at the Gallagher and Abellio case and the Gwyneth Council versus Barrett case. So I will now make a start. I said I'm looking at K versus L, and the first thing you'll have noticed, of course, is that it's only by, I suppose, initial, this one, so that indicates it's a sensitive matter, and you'll see why as we go along. K was a teacher, and L was the employing body, the local authority. He was a school teacher, and unfortunately, he was charged with possession of indecent images. There was a dawn raid on his house, I think in December 2015, and they recovered a computer, and the indecent images were found on that computer. Now, he had 20 years of unblemished service at the school, so no issues had arisen before with Kay, and he denied that he'd downloaded the images. Now, the computer, he said, was a shared computer. His son lived with him, and also his son's friends had access to that computer as well. So he basically said it wasn't him. And even though he was charged with the offence, the authorities ultimately decided not to prosecute, largely because they couldn't find any way of proving who had downloaded the images. Now, Kay did inform the headmaster, or the head teacher, about the charges and the inquiry, and not surprisingly, he was suspended pending investigation by the school. Now, as part of that investigation, the school did make inquiries of the authorities and asked for information about what was going on, and they received a restricted letter with lots of redactions and blanked out areas, but giving some information about their inquiries. Now, the dismissing of the decision maker, who was heading the disciplinary process, didn't get to see that letter, so it was only seen by some other members of the school staff. Now, the school took disciplinary action, not surprisingly, and focused very much on a misconduct charge, which related to the downloading of the indecent images. There was no reference at all in the disciplinary documents to reputational damage or anything else. Now, in the disciplinary process, Kay denied downloading the images, which was consistent with what he'd done before. But ultimately, he was still dismissed. The decision maker decided that Kay couldn't prove he hadn't downloaded the images, but also relied on the fact that there was significant reputational damage, for the school, and also made a reference to breaches of trust and confidence. Now, Kay took the claim to the tribunal, alleging that he'd been unfairly dismissed, and he was unsuccessful at tribunal level, but he did appeal it to the EAT, and the EAT upheld his appeal. They found for him, and the rationale for that finding was that an employer always must give the employee notice of the basis on which the dismissal is made. And here they hadn't done that. As we said, they'd focused on the misconduct issue, the downloading of the images, and hadn't made any reference to the reputational damage or reputational issues in the disciplinary paperwork. Also, in the way they'd framed it, they'd relied in a way almost on a potential conviction in the future because of what may or may not happen. The authorities had decided not to prosecute, but had kind of left it open, I think presumably in case other evidence came to light. But really, the EAT felt there wasn't enough evidence for the school, the employer, to come to any decision on a 51% basis that there would be any committing of future misconduct. So this was a really difficult, horrible situation for the school to be in. We know that Kay had disputed the charge, if you like, that underpinned this, and the authorities weren't prosecuting, but it was still left open. Very sensitive issue. Clearly, awareness of this by, the parent community could have led to all sorts of really difficult problems for the school. Well, I think the key things to take away from the case are always think hard about the allegations in a disciplinary situation. Try and set them out, even separately set them out, even if you think they're overlapping or they might interlink. Break them down, cover all the angles that you think possibly could lead to that decision. Where you might be dealing with reputational damage, it's also very important to try and gather that evidence. So don't make assumptions about damaged reputations. Get the evidence to show how widely this has been spread, that there has been reputational damage, not just suspected damage. Where the police or the authorities are involved, yeah, absolutely try and get as much information as you can from those. But also, and a problem here was the decision maker hadn't seen that information in this case. And also this point about concerns of potential future misconduct, which here might have related to whether the charge was ultimately brought back to life and substantiated. You really need to have the evidence in place to make decisions on that basis. The possibility of some future misconduct being found is not going to be enough. So an interesting case, I say one that's, I think, reiterated some key messages, but also touches on involvement of the police and the authorities and reputational issues, which we know can be very common. So, Kate, I'll hand over to you now on the Gallagher one.
Thank you, Tim. Yes, so I'm going to be looking at Gallagher and Abellio, and I think there might be a poll on this one with a very simple question. Basically, was she unfairly dismissed or not? I'll give you the facts, and then you'll have an opportunity to just click yes or no, I think. So Miss Gallagher was a senior manager in the company, and there'd been a breakdown in her working relationship with her own line manager, which had arisen as a result of various workplace disagreements. The claimant attended her annual appraisal and was told that within the appraisal that she was being dismissed for a lack of trust and confidence between her and her manager. There had been 2 previous meetings to consider the fact that the relationship was difficult, but there'd been no improvement in the situation. And so they took that opportunity to dismiss her simply because there was a breakdown between her and her manager. They were both quite senior people within the organisation. So I think the poll has popped up. So if you would like to decide whether you think those facts led to a fair dismissal, yes or no, I'll give you a few seconds before continuing. Okay, I can't actually see where we've got to with that. So I will carry on anyway. Um, so the answer to the question of whether she was unfairly dismissed was no, she wasn't unfairly dismissed. This is a very rare example, I would say, in terms of the process they followed, because they followed no process at all. And the tribunal basically went through everything and agreed that had a process taken place, it wouldn't have made any difference to the fact that she was dismissed, and actually could have made the matter worse, because their relationship was so strained, any process probably would have just exacerbated the issue. So the tribunal basically said a process would not holding a process would normally fall outside the band of reasonable responses for a respondent to take. But where it would be futile, they can dispense with them. Obviously, it's very difficult to know at the outset of a process and the outset of deciding whether you need to dismiss somebody, whether or not a process would be completely futile or not. So it's something I would be very, very cautious to advise any of my clients to do. But the fact was they were very senior managers, they'd lost trust and confidence in each other, and their working relationship was critical to the business. And the tribunal agreed ultimately that any process wouldn't have made a difference. So I think they were quite lucky with that outcome. So I will move on to Gwyneth and Barrett, which is another unfair dismissal case regarding redundancy. The claimants here were teachers employed by the council. The school that they worked at closed down, and they applied for new positions at a newly opened school. So obviously it wasn't the case that everybody at that school just automatically transferred. They were unsuccessful in their applications, and they were given written notice on the ground of redundancy that they were being dismissed. They were given no opportunity to make any representations on the dismissal, and they weren't given a right to an appeal. The Employment Tribunal decided they were not dismissed because of a redundancy situation. They were dismissed because of the method the respondent chose with which to deal with that situation. So the respondent made the choice of having a lack of an appeal or any kind of review process of this decision, or the process of having to apply for their own jobs at a new school. And the tribunal found that that was actually procedurally and substantively unfair, and that dismissal was not inevitable. There was an appeal on the ground that the Employment Tribunal should not have found that dismissal was not inevitable, that the tribunal erred in its approach to fairness, and that it failed to make a Polkey reduction. And most of you, I think, will understand that a Polkey reduction means that where something would have made no difference, compensation can be reduced accordingly. So the EAT basically threw everything out and said that there was no error in law. The dismissal as a result of redundancy was not inevitable, which they would have found had they followed a proper procedure. There was no error in regard to the fairness decision, and the whole Polkey argument will fall away once a decision has been made that dismissal was not inevitable. So basically, the claim succeeded in whole because of the lack of procedure, which obviously is very different to the case we just talked about. But I think that's the problem with the tribunal sometimes. It depends on the day who you get. So my advice is always to make sure that you follow at least some procedure, because failing to do so can be quite risky. I think we move on now to Barclays.
Thanks, Kate. I'll do that. And I say the poll results, not surprisingly, which I say came in just slightly later there when Kate was working through that one on the Gallagher case, not surprisingly had an overwhelming majority in favour of saying that basically she was unfairly dismissed. So it's interesting because, as Kate explained, it was quite an unusual set of circumstances where the seniority and the difficulty of the relationships led to the opposite result. So as Kate said, we'll move on to the next slide, and you'll see this one. Sorry, that's my fingers. You'll see this next one is headed Vicarious Liability. I can get back. There you go. And we're looking at two cases in this area. Always an interesting area. I'll be looking at the first one, the Barclays Bank versus various claimants, and Kate will look at the second one, the Morrison Supermarkets case. Both of these you may well have heard of already. So in short terms, when we're looking at vicarious liability, what does this mean? Well, really, this means the employer entity, being liable for actions of its employees. And this is the case even where the employer is not at fault in any way, so has done nothing wrong. So it's a kind of strict liability situation for the employer where, unfortunately, if this legal relationship is in place, you can be liable even to third parties for actions of employees. Now, one of the keys to establishing vicarious liability is that the employer can only really be liable for acts of employees that take place in the course of employment. And as you can imagine, there's been lots of litigation over the years as to what this phrase means, what is in the course of employment. It's often wider than people expect as well. But another case law trend has focused on, can this concept of vicarious liability apply to people who are not employees but perhaps occupy a similar position? And we've had cases where, for example, employees of subcontractors in a construction sense, even priests who are not employed by a diocese, or even in a prison context where vicarious liability has been triggered by the actions of a prisoner who, of course, again, is not employed by the prison. And this Barclays case I'm going to look at now, again, follows on this strand, looking at when non-employee relationships could give rise to that vicarious liability. So to look at the facts of this one, the bank required applicants for jobs to pass or to take part in a pre-employment medical examination. Dr. Bates was a GP, and he provided this service to the bank. He carried out pre-employment screening. Now, this screening by Dr. Bates was done in his consulting rooms, which were actually built into his home, so not on Barclays premises or locations. No chaperone or anyone accompanied the individuals who were getting screened. Now, tragically, after Dr. Bates passed away, 126 people made allegations that they'd been sexually assaulted during those examinations. Now, the 126 claimants pursued the bank for damages, and that was because of deep pockets. The bank would have the money to pay compensation where Dr. Bates' estate wouldn't be able to meet any liabilities. Now, actually, at the High Court and Court of Appeal, the claimants were successful in establishing that the bank was vicariously liable for the damages suffered. And that was because the courts at both levels had found that the relationship between the bank and Dr. Bates was close enough to be viewed as akin to employment. And secondly, there was a very close connection between how the abuse had taken place and the working relationship between Dr. Bates and the bank. Now, Barclays appealed this to the Supreme Court and were successful. So this is really a decision that is helpful to employers. So the Supreme Court found that the bank wasn't liable for the actions of Dr. Bates. And really what this was is almost a sort of affirmation of what you might call the independent contractor defense in vicarious liability. Because the Supreme Court found that all of the I suppose logistics around the appointment was handled by Dr. Bates. He set up his appointments. He made arrangements for the person to attend. He didn't have to do the screening. He could turn down the work, so he wasn't required to do the work. He had his own insurance policies in place for, I suppose, the medical malpractice side. And perhaps most importantly, the Supreme Court felt that he was very much an independent contractor in business for himself. He had a range of other clients and patients for whom he carried out work, and certainly not just the bank here. So taking those factors together, the Supreme Court decision was very much this was not a relationship that was akin to employment, and as a result, the claimants couldn't establish vicarious liability. So I say, a positive decision for the employer, really, when in years before this, there'd been kind of a push in the other direction. So that's all I want to say about the Barclays case, and I think Kate will now look at the Morrison's one.
Thank you. So yes, another vicarious liability case, and in this one went all the way to the Supreme Court. So it was Morrison Supermarkets and various claimants. And it concerned an employee who had deliberately uploaded payroll data to the internet in order to try and harm Morrison's. Clearly had a little bit of a grudge against Morrison's. So he did this at home using his own personal equipment. He did work for Morrison's within their accounts team. And this all centred around whether or not Morrison's should be held accountable for his actions as an employee and whether he performed those actions in the course of his employment. Ordinarily, employers will be liable for breaches committed by an employee under the doctrine of vicarious liability, where there is enough connection between the employment and the wrongdoing. So it's a two-stage test. Number one, is there a relationship between the primary wrongdoer and the person alleged to be liable, which is capable of giving rise to the liability? And number two, is the connection between the employment and the wrongful act so close that it would be just and reasonable to impose that liability on another person, legal person, on a company? So the Supreme Court has held that Morrison's was not vicariously liable for the actions of this employee who did this act, obviously without authorization and using personal equipment at home. This overturned the judgments of the High Court and the Court of Appeal, and the Supreme Court found that in the circumstances in which he'd committed that wrongful act, it was not so closely connected with his relationship with what he was authorized to do as to be regarded as having that liability for Morrison's. So they would never have authorized him to do any such thing. It was very, very much removed from what he was required to do at work. And therefore the Supreme Court said, no, Morrison's can't be held liable for this act, even though it's by an employee. I think move on.
Okay, thank you.
On the next slide, I think.
Okay, as Kate said, the next set of cases we're looking at are discrimination matters, where we're focusing on philosophical belief and gender assignment. And as Kate said, Kate's going to look at the first one, and I'll leave Kate to handle the pronunciation, and I'll pick up the Higgs and Farmer School one.
Just going to go for it. So we have Kasamit Jana and League Against Cruel Sports. He's an ethical vegan with very strong and entrenched beliefs about veganism. And so the Employment Tribunal has held at a preliminary hearing that a claimant's ethical veganism is protected under the Equality Act. The Employment Tribunal applied the normal test as to whether something can be held to be a philosophical belief. The test is written in a case called Granger, and the bullet points that they have to go through in order to try and assess this question are that the belief must be genuinely held. It must be a belief, not an opinion or viewpoint based on the present state of information available. It must be a belief as to a weighty and substantial aspect of human life and behaviour. It must attain a certain level of cogency, seriousness, cohesion and importance. And it must be worthy of respect in a democratic society, not be incompatible with human dignity and not conflict with the fundamental rights of others. And so the Employment Tribunal went through that test and held that the belief was genuinely held by the claimant and that it was more than an opinion. It had a weighty and substantial effect on his everyday life. He worked in animal protection and avoided relationships with non-vegans. He ate a 100% vegan diet. He avoided any foods that could potentially harm animals in their production, such as figs, which I meant to Google as why that harms animals, but I forgot to do that, so apologies for that. And would not allow any food or product containing animal products into his home. He avoided using any products tested on animals. He never wore anything that was made from animal-derived products, and he even avoided financial products that invested in companies that carried out animal testing. And he didn't use banknotes that were manufactured using animal products. I think the new paper notes have got a coating on them which is derived from animal products, so he doesn't use those. And he also would choose to walk somewhere rather than get public transport if his journeys were under an hour in order to avoid accidental crashes with wildlife. So this had a huge impact on his whole everyday life. And the Employment Tribunal held that, without a doubt, ethical veganism is a belief which contained a high-level cogency, cohesion and importance. And it's rooted in an ancient concept of ahisma, which means not to injure, and is an important tenet of several religions, including Hinduism and Buddhism. There's no conflict between veganism and human dignity, and it does not offend society or conflict with the fundamental rights of others. So I think previously there's been a bit of a question mark over whether veganism could be held to be a philosophical belief, but it looks like the tribunals are now much more willing to say, even at a very early stage in a case, this absolutely is a philosophical belief. Because this was found at a preliminary hearing, not even at the main hearing. So I think that's maybe moved us on a step.
Thanks, Kate. So now I'll move on to the Higgs and Farmers School case now. And this one does contain a poll, so I'll give people a heads up there that we've got a poll question on this one as well. So again, we'll ask that as we go through, and I'll try and keep an eye on the responses. So Higgs and Farmers School is an ET, so sort of an employment tribunal decision, but as we understand it is one that is being appealed to the EAT. And as we flagged, this is also another about discrimination in relation to religious and philosophical belief. Kate's already mentioned in the Casimichana case the fact that religion and belief is a potentially protected characteristic under the Equalities Act, and the 2010 case of Granger and Nicholson laid out those tests that Kate ran through. So they were the sort of almost the hoops that someone has to jump through in order to prove that. So I won't reiterate those, but I say they are the tests that the tribunal looks to. Now, in terms of the Higgs case specifically, there'd been a number of cases over the years that had focused on kind of Christian beliefs or some Christian beliefs, particularly in relation to this whole issue of gender fluidity, which obviously is a very current issue and has attracted a lot of publicity over recent years. And some Christian beliefs would be that this was incorrect and that was effectively two genders, male and female. Now, there'd been cases other than Higgs where this belief, if you like, had been tested against those Granger aspects and had fallen on, if you like, the wrong side of the line. So hadn't been held to be a philosophical belief that would meet the relevant standards to be a protected characteristic. One of those cases was called Forstater and CGD Europe, and one was called Makareth versus the DWP. And they really fell down almost on the last point, the fifth bullet point in the Granger test, which was either being held to be incompatible with human dignity or conflicted with the human rights of others, or wasn't worthy of respect in a democratic society. And it was those reasons why they fell to the wayside. So if we turn to the facts on the Higgs case, Mrs. Higgs was employed by Farmers School, and she was a pastoral manager and also a work experience coordinator. And I suppose this really starts with Mrs. Higgs putting posts on Facebook which triggered a complaint from outside of the school, a third party. And what Mrs. Higgs had done is she'd reposted an article and put comments on herself about brainwashing of children, and she'd been urging people to sign a petition. And actually the article itself was about schools teaching same-sex relationships and same-sex marriage and gender being a choice issue. And actually there were other Facebook posts by Mrs. Higgs which dealt with a similar area. Now, the outcome of all this was essentially that Mrs. Higgs was dismissed by the school after a disciplinary process for gross misconduct. And the school said that she'd breached their conduct policy, both in relation to discrimination, but also in terms of social media use. Now, Mrs. Higgs claimed discrimination at the tribunal. She said that she'd been discriminated on grounds of religious or philosophical belief, and she said her philosophical beliefs included her beliefs about gender and gender fluidity, her beliefs about sex education in schools, and her beliefs about some of the literal truths in the Bible. So I think the poll question has come up there. So do you think her beliefs ended up being protected under the Equality Act? Okay, now I think the results have come through actually, which is a fairly even split. So just in favour of no, that we don't think these beliefs were protected, but only marginally. So I say it was a very, very close result. That's interesting. Now, actually, the tribunal did decide that this had passed the Granger Test. So their decision was that this was a philosophical belief that could be protected under the Equality Act. Now, the tribunal did accept that this could upset people, so the views held by Mrs. Higgs could cause upset for other people, but they still believed it met, in particular, that last test. So they didn't believe that it wasn't worthy of scrutiny in a democratic society, and they didn't believe it conflicted with the fundamental human rights of others. Now, as it happened in the case itself, because Mrs. Higgs had alleged direct discrimination and harassment, actually she lost. Those claims were rejected by the tribunal, as it did find that it was the use of social media actually that motivated the dismissal, because it was the school's concern that the Facebook post meant that other people could perceive that Mrs. Higgs held views which were unacceptable to the LGBTQ community. Now, the Christian Legal Centre, I think, who backed the case, have also backed an appeal. And I mentioned the Forstater and Makareth cases, and I think they're all going to be appealed together. So, you know, there is a watch this space about that one, but I say that was interesting because it pushed in the other direction from the other two cases. So I'll hand over to Kate now for the Taylor versus Jaguar Land Rover case.
Thank you. So yes, another gender-related case, Taylor and Jaguar Land Rover. This concerned an employee who identified as gender fluid or non-binary, and the question for the tribunal was whether or not this was covered under the Equality Act, under the heading of gender reassignment, for the purposes of discrimination. And it's a very recent case, September, I think, this year. And the Employment Tribunal has upheld the claims for harassment, direct discrimination and victimisation on the ground of gender reassignment against Jaguar Land Rover in relation to an engineer who, Miss Taylor, who identified as gender fluid and non-binary and usually dressed in women's clothing. She was subjected to insults at work, abusive jokes, and suffered difficulties with the use of toilet facilities and managerial support. Now, a person who has the protected characteristic of gender reassignment needs to fulfil the criteria that they are proposing to undergo, are undergoing, or have undergone a process or part of a process for the purpose of reassigning their sex by changing physiological or other attributes of sex, which is under Section 7 of the Equality Act. The tribunal decided that she did fall into this category, they did fall into this category, and noted that this was a new point of law, but felt that in the circumstances enough had been done in order to identify as something other than the kind of norms of male and female assignment in order for that person to qualify under that section of the Act. So even though it doesn't sound what we expect from gender reassignment, there's been no process, there's been nothing happening to that person, they were held to have fallen under that category and therefore won the claim for harassment, direct discrimination and victimisation.
Thanks, Kate. So I say it's certainly, I say the Taylor versus Jaguar Land Rover is a very current issue, I'd say, and we all know there's been lots of news stories about gender fluidity, certainly in the last 12 or 18 months. So I say it probably shows that the wording in the Equality Act about gender reassignment was a little bit outdated in comparison to where the debate now has moved. And obviously the Taylor case has kind of shifted things, you know, with the times. So again, something that's important to keep in mind.
I don't think they've even given out written reasons yet, so I think this is just quite new, hot off the press kind of stuff. So. Yeah. So an interesting one. Okay. Now I'm going to move on to two TUPE cases. ISS Facility Services and Gwyneth, and then Ferguson and others versus Astria Asset Management.
Again, I think just a heads up, I think we've got another poll in the ISS case, but so that one will come at the end of what we've talked about. And I suppose ultimately, TUPE is one of those quite difficult areas that does give rise to a lot of litigation and also some quite complicated concepts. What we don't have time to do is to sort of run through how TUPE works in order to provide the sort of all of the background for these cases. But in very broad terms, for anyone who's not familiar with it, what we're talking about here is our transfer of undertakings protection of employment regulations. And they effectively deal with transfer situations between employees, where employees have their jobs protected and they move from one employer to another, typically in a sales situation where a business or part of a business has been sold, or as we'll see in the ISS case, where there's been what they call a service provision change, which really is triggered by someone outsourcing a function, changing a supplier of an outsourced function, or bringing that outsourced function back in-house. And that movement can lead to employees moving from one employer to another. And that is the protection that's covered underneath these regulations. So what we're looking at with the ISS case here is an ECJ decision. So it might be a collector's item following the end of this year. So it's an ECJ decision, which is binding on UK courts, and it's come from the Belgian jurisdiction. And I suppose what we'll find here is this is an ECJ decision that's making something that's pretty complicated even more complicated, which does arise in TUPE sometimes. So I apologise for that in advance. And what this case was looking at is what to do when there is more than one what they call transferee employer. So where we're talking about employees shifting from one employer to another, so where there are perhaps a number of employers. So just hypothetically, giving the simplest possible example, if you had an outsourcing situation for an employer, if you outsourced a function you currently carried out yourself, payroll or IT, but you outsourced it to 2 or 3 different suppliers, you would have potentially 2 or 3 different transferees. So that's what this case was looking at. So to look at the facts, ISS was a facilities and maintenance supplier in Belgium, and it was responsible for cleaning and maintaining sets of buildings. And the buildings in question were divided into 3 lots. And the claimant here, Mrs. Gwyneth, managed all 3 of those lots. Now, as sometimes happens, there was a tender, and ISS, unfortunately, lost the cleaning and maintenance contracts across all 3 of those building lots, so it lost everything. Now, lots 1 and 3 went to a new employer called Italian, and lot 2 went to a new employer called Cleaning Masters. So they became the new suppliers. So in terms of the context here, potentially they're the different transferees. Now, most of Mrs. Gwyneth's time was spent on lots 1 and 3. I think 85% of her time was spent on those groupings of buildings. So ISS, not surprisingly, had told Gwyneth that she was going to transfer to Italian, which was the employer that won those 2 lots in the bidding process. But, as does sometimes happen, Italian refused to accept Gwyneth as an employee, refused to accept that she'd been transferred to them. She was caught in the crossfire, left without employment, and brought a claim, and she brought claims against both ISS and Italian, essentially for notice pay, holiday pay, I think unpaid bonuses that she was owed at the end of her employment. This went through to Belgium's higher labour court, and although the court itself had come to the conclusion that there had been a transfer to Italian, it referred a question to the ECJ, and that question was effectively what would happen when there were multiple transferees. Now, this is where it gets unhelpful. The ECJ decided, surprisingly, that it was possible for an employment contract, so one employment contract, to transfer to more than one employer, effectively for that contract to be split into different parts. And that split would be done proportionally with the amount of work done by each transferee. Now, the ECJ helpfully recognised that this could be challenging and could potentially be impractical in some circumstances, and that could lead to a termination position for the employee involved. Now, why does this matter? That's, as I say, an ECJ decision coming from the Belgian jurisdiction. In the UK, our case law doesn't support this approach at all. In fact, it's kind of alien to our approach. The UK position on this has always been that the employment contract in a transfer situation like this would go across to whichever new supplier was inheriting the majority of the services or the work involved. So this decision could potentially be really very significant because it changes that picture completely. And now it could be incumbent on tribunals to assess, if you like, where there are a number of transferees, how that split could potentially work, how that contract of employment could be divided. And as I think that we'll come back to in a second, that could be very challenging. What's important is don't forget that TUPE might not apply anyway, so our transfer of undertakings regulations might not apply because the services before and after that transfer have to be fundamentally the same. So if there's going to be a transfer at all, that won't work if the services are broken up, chopped up into too many small parts, so you can't really follow what's happened. So using my hypothetical example, if you had 10 or 12 or 15 new suppliers for something that an employer had done itself, that might be too fragmented for TUPE to work. Also, if the services are done in a completely different way, that also might mean that TUPE couldn't be applicable because the services have to be fundamentally the same. But if there is a transfer, then this issue of how this splitting will work will need to be grappled with. You know, can the contract be divided up? How would it be divided up? If you're sending one employee with one contract of employment to more than one transferee, well, will that divide up by days? Will it be Monday and Tuesday at that employer and Wednesday to Friday at the other one? And if it can't be worked out, if it's not practical, that could lead to termination. Who will be liable for those termination risks? Will it be an automatically unfair dismissal? Because that's the case if someone is dismissed by reason of the transfer, unless there is what they call an economic, technical, or organizational reason, entailing changes in the workforce, which in normal language usually means some kind of restructuring or redundancy that's led to the changes, which has led to this position. So I think it's going to be a real difficult one. I think it's going to, cause a lot of thinking time over here. And I think where you are involved in a transfer situation, the important things are going to be to firstly always check whether TUPE is applicable in the first place, because if it's not, these problems fall away. If it is applicable and you've got more than one potential transferee, you're going to have to think very hard about practically whether a contract of employment could possibly be split. You're probably going to have to collaborate and discuss that with transferees, which is different to perhaps the current position, because it's going to require a much more collaborative process. And you're probably going to have to consult with the employees who could transfer to see if they think this is feasible or they think it will place them in a worse off position. Because if it is, it's more likely to end in termination, and then there'll be all sorts of issues about the liabilities, and that's going to mean your indemnities and warranties are also very important. So if we look to the poll, we've had that one there. So what do you think about this decision and whether it makes perfect sense? You don't know, you're not sure, or it's complete nonsense. And I say it's a very difficult one. I mean, I think in terms of the outcome there, not surprisingly, it's very mixed. And I think it's for me personally, I think it's not something I would say makes perfect sense. I think it is a nonsense decision. I think it'll lead to enormous practical problems for people to try and deal with, and I'm not sure how you'll end up splitting contracts unless it falls very neatly on a time basis. So it is very much a watch this space one in that case. Now, I'm going to look at another TUPE one called Ferguson versus Astria Asset Management, which is actually an EAT decision, so an Employment Appeal Tribunal decision here in the UK. And in terms of the background to this one, this relates to Regulation 4.4 of TUPE that basically says that any variation or change to the contract of employment for a transferring employee will be void if the sole or principal reason is the transfer itself. So this is essentially that when people transfer from one employer to the other, if changes are made to their terms and conditions, because they're inherited by the transferee, they will be void if the sole reason or the principal reason for that change is the transfer itself. So if we look at the facts, I think it will make it more clear. So the claimants here, Ferguson and others, were essentially directors of a business called Lancer. And Lancer, I think, managed property. And it had one client, which was the Abu Dhabi royal family, and it managed properties in Mayfair and Knightsbridge. Now, in 2017, Astria took over the management of these properties, and this triggered a TUPE transfer from Astria to Astria from Lancer, and that included Ferguson and the other, certainly the other directors. Now, before that transfer took place to Astria, the 4 directors of Lancer basically fiddled their service agreements. They lengthened their notice periods and they built in termination payments and made it, if you like, more lucrative for them if they were dismissed. Now, what happened is after they transferred to Astria, all 4 of them were dismissed by Astria for gross misconduct, which included the alteration of those contracts. Not surprisingly, the directors sued for unfair dismissal, but also for unpaid termination payments, which were significant, and they were some of the payments that they'd included in these variations before the transfer took place. Now, their argument was that following the previous case law over here on TUPE, positive changes, i.e. changes that were positive for the employees, such as increasing the notice period and termination payments, were binding on the new employer, on the transferee. Now, the ET, the tribunal, rejected this claim, but they relied on the view or the fact that this was an abuse of the legal process here. And not surprisingly, Ferguson and others appealed that. Now, the Employment Appeals Tribunal agreed there was no basis for this abuse principle. It had no relevance to Regulation 4.4, so that was not correct for the tribunal to take that view. But the EAT said that all variations to contractual terms, whether they were good or bad for the employee, were void if they were made by reason of the transfer. And actually what this meant was overturning a kind of principle that had come from a case called Power versus Regent Security back in the 90s, which had given rise to the idea that where changes were beneficial or positive for the employee, they would be binding, even if on the face of it, it fell foul of Regulation 4.4, but detrimental changes would be void, would be non-binding. Now, technically, Power was a decision under the older TUPE regs. The TUPE regs were refreshed in 2006, and actually there wasn't a Regulation 4.4 before, but what the EAT felt was that actually it didn't confer a general principle that only negative changes should be seen as void and positive ones would be binding. In effect, that the employee could cherry pick. You could have the benefit of any good changes, but you could say that bad changes were void. So the EAT in this case, Ferguson, clarified that any change by reason of the transfer is void, whether it's good or bad. So that's helpful, and I think it's kind of cleared up that position for us. But also it's worth keeping in mind that in terms of Regulation 4.4 itself, there are still some exceptions, and one of those areas was touched on here. And although the EAT had clarified that changes to existing contract terms would be void, it left the door open concerning additional rights. So new or additional rights that were perhaps granted before the transfer, so not changes to terms, may be enforceable. And the EAT said that's what they really took from the Power case before. That's what they felt the Power case was trying to say. So if it's a new thing that's given, that's possibly going to be enforceable. But also it's worth keeping in mind that variations are permitted under Regulation 4.4 in some circumstances anyway. So if the variation or the changes to the contractual terms is not for the sole or principal reason of the transfer, then that's fine, the change can be made. Where the reason is for an ETO reason, one we've mentioned already, so essentially a restructuring or a redundancy program, if that gives rise to changes, that can be acceptable. And also where the contract itself might permit the change. So if the contract itself is worded in a way that allows the particular change to be made, well, again, that will be acceptable. So an interesting case, probably not quite as complex as the ISS one, but helpfully clarifying this area of changes being void if they are by reason of the transfer. So at least we all know now that it doesn't matter whether they're beneficial or detrimental, they will be void. So those are the cases that we wanted to look at. So if I pop forward, so we said we'd look at what's in the pipeline very briefly. Now, what's in the pipeline is essentially our horizon scanning piece. It's a very short list this time. It's often much, much longer in our employment club sessions. And I think obviously for pretty straightforward reasons, the government has an awful lot on its plate at the moment, dealing with COVID-19 and also Brexit as one of the bullets. there isn't that much in the pipeline for the kind of the following year. But ones I was going to mention briefly, in terms of ACAS early conciliation, there are some changes coming in from December the 1st. So in terms of the EC period, the conciliation period, that will be extended to 6 weeks rather than the current month, because the current situation is it's a month, but you can extend it by agreement for 14 days. So that will be gone. It will just be for a 6-week period, which will be more straightforward. And also, the conciliator will be able to correct technical errors on the EC form submitted by the claimant, because that can sometimes lead to technical arguments which aren't really helpful. I'll jump past the immigration rules. In terms of Brexit implementation period, as we all will know, that the implementation period for Brexit finishes on 31st December at 11 p.m. So really, until that period, it is business as usual in relation to our law. So EU legislation is still binding. ECJ decisions are still binding on UK courts. We can still make ECJ referrals. But I suppose effectively, once we hit 1st January 2021, things change. What will happen then is the current law, the current EU law, will be crystallised and it will be retained in the UK, but it will be static. So it will stop at that point and it will remain as it is. And that essentially means that any new UK legislation after that 1st January date will override European law that conflicts with it. It will also mean that the ECJ is no longer the supreme sort of legal court. We will not be making ECJ referrals, and ECJ decisions will not be binding on us from that point. And I suppose it also means we would then have to look at what will happen to employment law after that Brexit implementation period comes to a close. And what we know is that the government moved the sort of level playing field declaration into the non-binding section now. And that means really that in terms of aligning our employment rights, it will probably be dictated by a trade deal. So we don't know what will happen there. And there certainly could be key areas of law that the government could consider as perhaps ripe for a change after 1st January. And that could include everything from caps on discrimination awards, whether trade union recognition could be made more challenging, whether it will be made more difficult for people to organise strikes on public transport, whether they will look at working time rights, particularly holiday pay, and perhaps try and simplify that, perhaps getting rid of the 48-hour limit on the working week. Some TUPE changes, perhaps making it easier to harmonise terms and conditions after a transfer. So there might be a whole raft of areas that the government could consider, but obviously we don't know that now. And the last point on there quickly is just that the off-payroll working concept, the IR35 rule, which has been in place for the public sector for a while now, was due to be implemented in the private sector on the 6th of April 2020. It was then paused because of COVID, and it's now going to come into effect on the 6th of April 2021. And in a nutshell, what this means is where you've got individuals who provide services through personal service companies to an end user or a client, the new rules will mean that that end user will have to make a decision to categorize whether that is effectively disguised employment, and where it is, it means that the person who pays that personal service company has to essentially put them on the payroll and deduct tax and NI. So it will change that quite significantly. It's had a significant impact on the public sector. We understand, or we believe it's likely to apply to payments made after the 6th of April 2021 for services rendered after that point as well. So just a heads up on that one. Okay. That was that. So we can now, got a few minutes just to have a look at any questions and answers that have been raised. So I'm just going to look at that. So I'm just scrolling down now. Right, okay. In terms of questions. Well, one we've had in terms of the Brexit point, which we've just touched on, was what areas of law do we think might be ripe for a change? And, you know, I've touched on a number of those already. In terms of my view and for my money, I think the most likely perhaps focus could be two areas: holiday pay under the working time regulations, which has caused a lot of problems, how that holiday pay is calculated, and how perhaps people accrue holiday when they're absent with sickness. So I think that might be right for a change. I also think the TUPE issue of being able to harmonise terms and conditions after a transfer would be one that could come into place. Another question we've had is in relation to, I suppose, the COVID-19 situation, and someone has asked, whether the COVID-19 situation has had an impact on unfair dismissals and redundancies. I think the very short answer to that one is, of course, that we've known for quite a long time, dealing with a whole range of clients, that clearly a lot of redundancy dismissals are going to be triggered by the COVID situation. Things have changed very rapidly. Obviously, the new furlough scheme and the extension of the furlough scheme will hopefully make a difference, but it certainly will increase redundancy claims coming into the system and and there is a potential for unfair dismissal aspects to be part of that. Particularly one of the issues that's come up is whether or not placing someone in furlough and making them redundant could be part of an unfair dismissal assessment. I think what we've been saying to people is potentially, and it's always worth considering whether there is a furlough option before making someone redundant, but it's not mandatory, it's not an obligation, it would just be one of a number of factors that might be assessed. Okay, I'm just looking down the other questions that have come in. So I've had one there, okay, on TUPE. If there was no employment contract in place prior to the sale of the business, would new contracts be void if these included an alignment of terms, introducing non-compete clauses? Interesting question. I think the short answer to that one, or shortish answer for TUPE, is if you haven't got a written contract, there's still a contract in place. It's just that the courts and tribunals have to decide what provisions are in place. So they would have to make an assessment as to what provisions were in place. And if you were introducing things like restrictive covenants or non-compete clauses, I think, essentially, if there was nothing there beforehand, it's going to be very hard for a tribunal to assess they should be in place. If you're introducing new ones to align with people currently in the employment population, well, firstly, you'd have the harmonisation point, which is you can't harmonise terms and conditions at the moment, which we've said already is one of those areas the government could look at. So you couldn't just be in a position to say, well, they are now going to be deemed to be part of your new contract of employment because you've transferred to us, but rather you would have to agree to try and introduce them, and you'd probably also have to try and make sure that it wasn't by reason of the transfer, which is the harmonisation point. So, I think that's probably a question that we would have answered the same, at any point. I think we've probably got time for one or two more very, very quickly. We've had some comments on the figs that Kay mentioned, so I'll skip.
I was going to say that.
I'll skip past that one. I think there's a question saying, do we think the IR35 stuff could be delayed again? Crystal ball time, not really sure. I mean, obviously at the moment, the position is, as I've flagged, it's expected to come in on the 6th of April 2021. I don't know if there's any chance the government would look at it again because, say, it has been postponed already for a considerable period of time. So I think for my money, I would probably make the assumption that IR35 in the private sector for medium and larger businesses will click into effect on that date. I certainly wouldn't plan for it not happening. Right, I'll see if I can do one more.
There's been a couple of questions on whether something's been appealed. So I think somebody's asked if Gallagher appealed, and yes,
okay.
they did, and it was dismissed. So there was no change there. And somebody has asked whether Taylor, the case of Jaguar Land Rover, has or will appeal. Obviously, it's very, very early days, so we don't know yet. I think Jaguar Land Rover actually issued a written statement apologising that she had been treated in this way. So whether they will appeal, I don't know. The award was 180,000, so they might think it's enough to warrant going forward with an appeal. But also, publicity-wise, perhaps they might be thinking that they should just let it go. We just have to wait.
Great. Okay. Well, thanks for that, Kate, as well. So thank you, everyone, for joining us. So I'm conscious it's 11:02, so I don't want to run on because we said we would stick with the hour. So thank you for taking part in the session. Thank you for submitting your questions and answers, and thank you very much for responding to the polls. As we said right at the start, the session has been recorded, and obviously that will be distributed to everyone who signed up to attend. So obviously you can replay it if you want to. So thank you very much for attending, and I say have a good rest of the day.